Hello, everyone. Today's case is Planned Parenthood versus Casey. So, this is the next iteration of the court revisiting the Roe versus Wade opinion. So, let's see what they had to say in 1992. At issue are 5 provisions of the Pennsylvania Abortion Control Act of 1982, subsection 3205, which requires that a woman seeking an abortion give her informed consent prior to the procedure and specifies that she be provided with certain information at least 24 hours before the abortion is performed. Subsection 3206, which mandates the informed consent of one parent for a minor to obtain an abortion, but provides a judicial bypass procedure, subsection 3209, which commands that unless certain exceptions apply, a married woman seeking an abortion must sign a statement indicating that she has notified her husband, subsection 3203, which defines a medical emergency that will excuse compliance with the foregoing requirements, and subsections 3207B, 3214A, and 3214F, which impose certain reporting requirements on facilities providing abortion services. Before any of the provisions took effect, the petitioners, 5 abortion clinics, and a physician representing himself, and a class of doctors who provide abortion services brought this suit, seeking a declaratory judgment that each of the provisions was unconstitutional on its face, as well as injunctive relief. The district court held all the provisions unconstitutional and permanently enjoined their enforcement. The Court of Appeals affirmed in part and reversed in part, striking down the husband notification provision but upholding the others. Held. The judgment in number 91-902 is affirmed. The judgment in number 91-744 is affirmed in part and reversed in part, and the case is remanded. 94F. This is just affirmed in part. Justice O'Connor, Justice Kennedy, and Justice Souter delivered the opinion of the court with respects to parts 1, 2, and 3, concluding that consideration of the fundamental constitutional question resolved by Roe v. Wade, principles of institutional integrity, and the rule of stare decisis require that Roe's essential holding be retained and reaffirmed as to each of its 3 parts. A recognition of a woman's right to choose to have an abortion before fetal viability and to obtain without undue interference from the state, whose pre-viability interests are not strong enough to support an abortion prohibition, or the imposition of substantial obstacles to the woman's effective right to elect the procedure. A confirmation of the state's power to restrict abortions after viability if the law contains exceptions for pregnancies endangering a woman's life or health. And 3, the principle that the state has legitimate interests from the outset of the pregnancy in protecting the health of the woman and the life of the fetus that may become a child. A re-examination of the principles that define the woman's rights and the state's authority regarding abortions is required by the doubt this court's subsequent decisions have cast upon the meaning and reach of Roe's central holding, by the fact that the Chief Justice would overrule Roe, and by the necessity that state and federal courts and legislatures have adequate guidance on the subject. Roe determined that a woman's decision to terminate her pregnancy is a liberty protected against state interference by the substantive component of the Due Process Clause of the 14th Amendment. Neither the Bill of Rights nor the specific practices of states at the time of the 14th Amendment adoption marks the outer limits of the substantive sphere of such liberty. Rather, the adjudication of substantive due process claims may require this court to exercise its reasoned judgment in determining the boundaries between the individual's liberty and the demands of organized society. The court's decisions have afforded constitutional protection to personal decisions relating to marriage, Loving v. Virginia, procreation, Skinner v. Oklahoma, family relationships, Prince versus Massachusetts, child rearing and education, Pierce versus Society of Sisters, and contraception, Griswold versus Connecticut, and have recognized the right of the individual to be free from unwarranted governmental intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child, Eisenstadt v. Baird. Roe's central holding properly invoked the reasoning and tradition of these precedents. Application of the doctrine of stare decisis confirms that Roe's essential holding should be reaffirmed. In re-examining that holding, the court's judgment is informed by a series of prudential and pragmatic considerations designed to test the consistency of overruling the holding with the ideal of the rule of law, and to gauge the respective costs of reaffirming and overruling. Although Roe has engendered opposition, it has in no sense proven unworkable, representing as it does a simple limitation beyond which a state law is unenforceable. The Roe rules limitation on state power could not be repudiated without serious inequity to people who, for 2 decades of economic and social developments, have organized intimate relationships and made choices that define their views of themselves and their places in society, in reliance on the availability of abortion in the event that contraception should fail. The ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives. The Constitution serves human values, and while the effect of reliance on Roe cannot be exactly measured, neither can the certain costs of overruling Roe for people who have ordered their thinking and living around that case be dismissed. No evolution of legal principle has left Roe's central rule of doctrinal anachronism discounted by society. If Roe is placed among the cases exemplified by Griswold, it is clearly in no jeopardy since subsequent constitutional developments have neither disturbed nor do they threaten to diminish the liberty recognized in such cases. Similarly, if Roe is seen as stating a rule of personal autonomy and bodily integrity, akin to cases recognizing limits on governmental power to mandate medical treatment or to bar its rejection, this court's post-Roe decisions accord with Roe's view that a state's interest in the protection of life falls short of justifying any plenary override of individual liberty claims. Finally, if Roe is classified as sui generis, there clearly has been no erosion of its central determination. It was expressly reaffirmed in Akron versus Akron Center for Reproductive Health and Thornburg versus American College of Obstetricians and Gynecologists, and in Webster versus Reproductive Health Services. A majority either voted to reaffirm or declined to address the constitutional validity of Roe's central holding. No change in Roe's factual underpinning has left its central holding obsolete, and none supports an argument for its overruling. Although subsequent maternal health care advances allow for later abortions safe to the pregnant woman, the post-Roe neonatal care developments have advanced viability to a point somewhat earlier. These facts go only to the scheme of time limits on the realization of competing interests. Thus, any later divergences from the factual premises of Roe have no bearing on the validity of its central holding. That viability marks the earliest point at which the state's interest in fetal life is constitutionally adequate to justify a legislative ban on non-therapeutic abortions. The soundness or unsoundness of that constitutional judgment in no sense turns on when viability occurs. Whenever it may occur, its attainment will continue to serve as the critical fact. A comparison between Roe and two decisional lines of comparable significance, the line identified with Lochner versus New York and the line that began with Plessy versus Ferguson, confirms the result reached here. Those lines were overruled by respectively West Coast Hotel Company versus Parrish and Brown v. Board of Education, on the basis of facts or an understanding of facts changed from those which furnished the claimed justifications for the earlier constitutional resolutions. The overruling decisions were comprehensible to the nation and defensible, as the court's responses to changed circumstances. In contrast, because neither the factual underpinnings of Roe's central holding nor this court's understanding of it has changed, and because no other indication of weakened precedent has been shown, the court could not pretend to be re-examining Roe with any justification beyond a present doctrinal disposition to come out with differently from the Roe court. That is an inadequate basis for overruling a prior case. Overruling Roe's central holding would not only reach an unjustifiable result under stare decisis principles, but would seriously weaken the court's capacity to exercise the judicial power and to function as the Supreme Court of a nation, dedicated to the rule of law. Where the court acts to resolve the sort of unique, intensely divisive controversy reflected in Roe, its decision has a dimension not present in normal cases and is entitled to rare precedential force to counter the inevitable efforts to overturn it and to thwart its implementation. Only the most convincing justification under accepted standards of precedent could suffice to demonstrate that a later decision overruling the first was anything but a surrender to political pressure and an unjustified repudiation of the principle on which the court staked its authority in the first instance. Moreover, the country's loss of confidence in the judiciary would be underscored by condemnation for the court's failure to keep faith with those who support the decision at a cost to themselves. A decision to overrule Roe's essential holding under the existing circumstances would address error if the error was at the cost of both profound and unnecessary damage to the court's legitimacy and to the nation's commitment to the rule of law. Justice O'Connor, Justice Kennedy, and Justice Souter concluded in Part 4 that an examination of Roe v. Wade and subsequent cases reveals a number of guiding principles that should control the assessment of the Pennsylvania statute. To protect the central right recognized by Roe while at the same time accommodating the state's profound interest in potential life, the undue burden standard should be employed. An undue burden exists, and therefore a provision of law is invalid if its purpose or effect is to place substantial obstacles in the path of a woman seeking an abortion before the fetus attains viability. Roe's rigid trimester framework is rejected. To promote the state's interest in potential life throughout pregnancy, the state may take measures to ensure that the woman's choice is informed. Measures designed to advance this interest should not be invalidated if their purpose is to persuade the woman to choose childbirth over abortion. These measures must not be an undue burden on the right. As with any medical procedure, the state may enact regulations to further the health or safety of a woman seeking an abortion, but may not impose unnecessary health regulations that present a substantial obstacle to a woman seeking an abortion. Adoption of the undue burden standard does not disturb Roe's holding that regardless of whether exceptions are made for particular circumstances, a state may not prohibit any woman from making the ultimate decision to terminate her pregnancy before viability. Roe's holding that subsequent to viability, the state in promoting its interest in the potentiality of human life may, if it chooses, regulate and even proscribe abortion except where it is necessary in appropriate medical judgment for the preservation of the life or health of the mother, is also affirmed. Justice O'Connor, Justice Kennedy, and Justice Souter delivered the opinion of the court with respect to parts 5A and 5C, concluding that as construed by the Court of Appeals, subsection 3203's medical emergency definition is intended to assure that compliance with the state's abortion regulations would not in any way pose a significant threat to a woman's life or health, and thus does not violate the essential holding of Roe. Although the definition could be interpreted in an unconstitutional manner, this court defers to lower federal court interpretations of state law unless they amount to plain error. Section 3209's husband notification provision constitutes an undue burden and is therefore invalid. A significant number of women will likely be prevented from obtaining an abortion just as surely as if Pennsylvania had outlawed the procedure entirely. The fact that subsection 3209 may affect fewer than 1% of women seeking abortions does not save it from facial invalidity, since the proper focus of constitutional inquiry is the group for whom the law is a restriction, not the group for whom it is irrelevant. Furthermore, it cannot be claimed that the father's interest in the fetus's welfare is equal to the mother's protected liberty, since it is an inescapable biological fact that state regulation with respect to the fetus will have a far greater impact on the pregnant woman's bodily integrity than it will on the husband. Section 3209 embodies a view of marriage consonant with the common law status of married women, but repugnant to this court's present understanding of marriage and of the nature of the rights secured by the Constitution. Justice O'Connor, Justice Kennedy, and Justice Souter, joined by Justice Stevens, concluded in Part 5E that all of the statute's record-keeping and reporting requirements, except that relating to spousal notice, are constitutional. The reporting provision relating to the reason a married woman has not notified her husband that she intends to have an abortion must be invalidated because it places an undue burden on a woman's choice. Justice O'Connor, Justice Kennedy, and Justice Souter concluded in Parts 5B and 5D that Section 3205's informed consent provision is not an undue burden on a woman's constitutional right to decide to terminate a pregnancy. To the extent Akron 1 and Thornburg find a constitutional violation when the government requires, as it does here, the giving of truthful, non-misleading information about the nature of the abortion procedure, the attendant health risks and those of childbirth, and the probable gestational age of the fetus, those cases are inconsistent with Roe's acknowledgement of an important interest in potential life and are overruled. Requiring that the woman be informed of the availability of information relating to the consequences to the fetus does not interfere with a constitutional right of privacy between a pregnant woman and her physician, since the doctor-patient relation is derivative of the woman's position and does not underlie or override the abortion right. Moreover, the physician's First Amendment rights not to speak are implicated not only as part of the practice of medicine, which is licensed and regulated by the state. There is no evidence here that requiring a doctor to give the required information would amount to a substantial obstacle to a woman seeking an abortion. The premise behind Akron 1's invalidation of a waiting period between the provision of the information deemed necessary to informed consent and the performance of an abortion is also wrong. Although subsection 3205's 24-hour waiting period may make some abortions more expensive and less convenient, it cannot be said that it is invalid on the present record and in the context of this facial challenge. Section 3206's one-parent consent requirement and judicial bypass procedure are constitutional. Justice Blackmun concluded that application of the strict scrutiny standard of review required by this court's abortion precedents results in the invalidation of all the challenge provisions in the Pennsylvania statute, including the reporting requirements, and therefore concurred in the judgment that the requirement that a pregnant woman report her reasons for failing to provide spousal notice is unconstitutional. The Chief Justice, joined by Justice White, Justice Scalia, and Justice Thomas, concluded that although Roe v. Wade is not directly implicated by the Pennsylvania statute, which simply regulates and does not prohibit abortion, a re-examination of the fundamental right Roe accorded to a woman's decision to abort a fetus with the concomitant requirement that any state regulation of abortion survive strict scrutiny is warranted by the confusing and uncertain state of this court's post-Roe decision law. A review of post-Roe cases demonstrate both that they have expanded upon Roe in imposing increasingly greater restrictions on the states, and that the court has become increasingly more divided, none of the last three such decisions having commanded a majority opinion. This confusion and uncertainty complicated the task of the Court of Appeals, which concluded that the undue burden standard adopted by Justice O'Connor in Webster and Hodgson governed the present cases. The Roe Court reached too far when it analogized the right to abort a fetus to the right involved in Pierce v. Society of Sisters, Meyer v. Nebraska, Loving v. Virginia, and Griswold v. Connecticut, and thereby deemed the right to abortion to be fundamental. None of these decisions endorsed an all-encompassing right to privacy. Because abortion involves the purposeful termination of potential life, the abortion decision must be recognized as sui generis, different in kind from the rights protected in the earlier cases under the rubric of personal or family privacy and autonomy, and the historical traditions of the American people, as evidenced by the English common law and by the American abortion statutes in existence both at the time of the 14th Amendment's adoption and Roe's issuance, do not support the view that the right to terminate one's pregnancy is fundamental. Thus, enactments abridging that right need not be subjected to strict scrutiny. The undue burden standard, adopted by the joint opinion of Justice O'Connor, Kennedy, and Souter, has no basis in constitutional law and will not result in the sort of simple limitation easily applied which the opinion anticipates. To evaluate abortion regulations under that standard, judges will have to make the subjective, unguided determination whether the regulations place substantial obstacles in the path of a woman seeking an abortion, undoubtedly engendering a variety of conflicting views. The standard presents nothing more workable than the trimester framework the joint opinions discards, and will allow the court, under the guise of the Constitution, to continue to impart its own preferences on the states in the form of a complex abortion code. The correct analysis is that set forth by the plurality opinion in Webster. A woman's interest in having an abortion is a form of liberty protected by the Due Process Clause, but states may regulate abortion procedures in ways rationally related to a legitimate state interest. Section 3205's requirements are rationally related to the state's legitimate interest in assuring that a woman's consent to an abortion be fully informed, the requirement that a physician disclose certain information about the abortion procedure and its risks and alternatives is not a large burden and is clearly related to maternal health and the state's interest in informed consent. In addition, a state may rationally decide that physicians are better qualified than counselors to impart this information and answer questions about the abortion alternatives' medical aspects. The requirement that information be provided about the availability of paternal child support and state-funded alternatives is also related to the state's informed consent interest and furthers the state's interest in preserving unborn life. That such information might create some uncertainty and persuade some women to forego abortions only demonstrates that it might make a difference and is therefore relevant to a woman's informed choice. In light of this plurality's rejection of Roe's fundamental right approach to this subject, the court's contrary holding in Thornburg is not controlling here. For the same reason, this court's previous holding, invalidating a state's 24-hour mandatory waiting period, should not be followed. The waiting period helps ensure that a woman's decision to abort is a well-considered one, and rationally furthers the state's legitimate interest in maternal health and an unborn life. It may delay but does not prohibit abortions, and both it and the informed consent provisions do not apply in medical emergencies. The statute's parental consent provision is entirely consistent with this court's previous decisions involving such requirements. It is reasonably designed to further the state's important and legitimate interest in the welfare of its young citizens, whose immaturity, inexperience, and lack of judgment may sometimes impair their ability to exercise their rights wisely. Section 3214A's requirement that abortion facilities file a report on each abortion is constitutional because it rationally furthers the state's legitimate interests in advancing the state of medical knowledge concerning maternal health and prenatal life, in gathering statistical information with respect to patients, and ensuring compliance with other provisions of the Act, while keeping the reports completely confidential. Public disclosure of other reports made by facilities receiving public funds, those identifying the facilities and any parent, subsidy, or affiliated organizations, subsection 3207B, and those revealing the total number of abortions performed, broken down by trimester, subsection 3214F, are rationally related to the state's legitimate interest in informing taxpayers as to who is benefited from public funds and what services the funds are supporting, and records relating to the expenditure of public funds are generally available to the public under Pennsylvania law. Justice Scalia, joined by the Chief Justice, Justice White, and Justice Thomas, concluded that a woman's decision to abort her unborn child is not a constitutional protected liberty because, 1, the Constitution says absolutely nothing about it, and 2, the longstanding tradition of American society have permitted it to be legally proscribed. The Pennsylvania statute should be upheld in its entirety under the rational basis test. Okay. O'Connor, Kennedy, and Souter announced the judgment of the court and delivered the opinion of the court with respects to parts 1, 2, 3, 5A, 5C, and 6, in which Blackmun and Stevens joined, and opinion with respect to part 5E, in which Stevens joined, and an opinion in which parts 4, 5B, and 5D, Stevens filed an opinion concurring in part and dissenting in part. Blackmun filed an opinion concurring in part, concurring in the judgment in part and dissenting in part. Rehnquist filed an opinion concurring in the judgment in part and dissenting in part, in which White, Scalia, and Thomas joined. Justice Scalia filed an opinion concurring in the judgment in part and dissenting in part, in which Rehnquist, White, and Thomas joined. Justice O'Connor, Justice Kennedy, and Justice Souter announced the judgment of the court and delivered the opinion of the court with respect to parts 1, 2, 3, 5A, 5C, and 6, and opinion with respect to part 5E, and in which Justice Stevens joined, and an opinion with respect to parts 4, 5B, and 5D. Liberty finds no refuge in a jurisprudence of doubt. Yet 19 years after our holding that the Constitution protects a woman's right to terminate her pregnancy in its early stages, that definition of liberty is still questioned. Joining the respondents as amici curiae, the United States, as it has done in 5 other cases in the last decade, again asks us to overrule Roe. At issue in these cases are 5 provisions of the Pennsylvania Abortion Control Act of 1982, as amended in 1988 and 1989. Relevant portions of the act are set forth in the appendix. The act requires that a woman seeking an abortion give her informed consent prior to the abortion procedure, and specifies that she be provided with certain information at least 24 hours before the abortion is performed. For a minor to obtain an abortion, the Act requires the informed consent of one of her parents, but provides for a judicial bypass option if the minor does not wish to or cannot obtain a parent's consent. Another provision of the Act requires that, unless certain exceptions apply, a married woman seeking an abortion must sign a statement indicating that she has notified her husband of her intended abortion. The act exempts compliance with these three requirements in the event of a medical emergency, which is defined in subsection 3203 of the act. In addition to the above provisions regulating the performance of abortions, the act imposes certain reporting requirements on facilities that provide abortion services. Before any of these provisions took effect, the petitioners, who are 5 abortion clinics and 1 physician representing himself, as well as a class of physicians who provide abortion services, brought this suit seeking declaratory and injunctive relief. Each provision was challenged as unconstitutional on its face. The district court entered a preliminary injunction against the enforcement of the regulations and, after a 3-day bench trial, held all the provisions at issue here unconstitutional, entering a permanent injunction against Pennsylvania's enforcement of them. The Court of Appeals for the Third Circuit affirmed in part and reversed in part, upholding all of the regulations except for the husband notification requirement. We granted certiorari. The Court of Appeals found it necessary to follow an elaborate course of reasoning, even to identify the first premise to use to determine whether the statute enacted by Pennsylvania meets constitutional standards. In an oral argument in this court, the attorney for the parties challenging the statute took the position that none of the enactments can be upheld without overruling Roe v. Wade. We disagree with that analysis, but we acknowledge that our decisions after Roe cast doubt upon the meaning and reach of its holding. Further, the Chief Justice admits that he would overrule the central holding of Roe and adopt a rational relationship test as the sole criterion of constitutionality. State and federal courts, as well as legislatures throughout the Union, must have guidance as they seek to address this subject in conformance with the Constitution. Given these premises, we find it imperative to review once more the principles that define the rights of the woman and the legitimate authority of the state respecting the termination of pregnancies by abortion procedures. After considering the fundamental constitutional questions resolved by Roe, principles of institutional integrity, and the rule of stare decisis, we are led to conclude this: the essential holding of Roe v. Wade should be retained and once again reaffirmed. It must be stated at the outset and with clarity that Roe's essential holding, the holding we affirm, has 3 parts. First is a recognition that the right of the woman to choose to have an abortion before viability and to obtain it without undue interference from the state. Before viability, the state's interests are not strong enough to support a prohibition of abortion or the imposition of a substantial obstacle to the woman's effective right to elect the procedure. Second is a confirmation of the state's power to restrict abortions after fetal viability, if the law contains exceptions for pregnancies which endanger the woman's life or health. And third is the principle that the state has legitimate interests from the outset of the pregnancy in protecting the health of the woman and the life of the fetus that may become a child. These principles do not contradict one another, and we adhere to each. Constitutional protection of the woman's decision to terminate her pregnancy derives from the Due Process Clause of the 14th Amendment. It declares that no state shall deprive any person of life, liberty, or property without due process of law. The controlling word in the cases before us is liberty. Although a literal reading of the clause might suggest that it governs only the procedures by which a state may deprive persons of liberty for at least 105 years, since Mugler v. Kansas, the clause has been understood to contain a substantive component as well, one barring certain government actions regardless of the fairness of the procedures used to implement them. As Justice Brandeis, joined by Justice Holmes, observed, despite arguments to the contrary which had seemed to me persuasive, it is settled that the Due Process Clause of the 14th Amendment applies to matters of substantive law as well as to matters of procedure. Thus, all fundamental rights comprised within the term liberty are protected by the federal Constitution from invasion by the states. The guarantees of due process, though having their roots in Magna Carta's Per Legem Terrae, and considered as procedural safeguards against executive usurpation and tyranny, have in this country become bulwarks against arbitrary legislation. The most familiar of the substantive liberties protected by the 14th Amendment are those recognized by the Bill of Rights. We have held that the Due Process Clause of the 14th Amendment incorporates most of the Bill of Rights against the states. It is tempting, as a means of curbing the discretion of federal judges, to suppose that liberty encompasses no more than those rights already guaranteed to the individual against federal interference by the express provisions of the first 8 amendments to the Constitution. But of course, this court has never accepted that view. It is also tempting, for the same reason, to suppose that the Due Process Clause protects only those practices defined at the most specific level that were protected against government interference by other rules of law when the 14th Amendment was ratified. But such a view would be inconsistent with our law. It is a promise of the Constitution that there is a realm of personal liberty which the government may not enter. We have vindicated this principle before. Marriage is mentioned nowhere in the Bill of Rights, and interracial marriage was illegal in most states in the 19th century. But the court was no doubt correct in finding it to be an aspect of liberty protected against state interference by the substantive component of the Due Process Clause in Loving v. Virginia, relying in an opinion for 8 justices on the Due Process Clause. Similar examples may be found in Turner v. Safley and Carey v. Population Services International, in Griswold v. Connecticut, as well as in separate opinions of a majority of the members of the court in that case. Goldberg, joined by Chief Justice Warren, and Brennan concurring, expressly relying on due process. Harlan concurring in judgment. White concurring in judgment in Pierce v. Society of Sisters and in Meyer v. Nebraska. Neither the Bill of Rights nor the specific practices of states at the time of the adoption of the 14th Amendment marks the outer limits of the substantive sphere of liberty which the 14th Amendment protects. As the second Justice Harlan recognized, the full scope of the liberty guaranteed by the Due Process Clause cannot be found in or limited by the precise terms of the specific guarantees elsewhere provided in the Constitution. This liberty is not a series of isolated points pricked out in terms of the taking of property, the freedom of speech, press, and religion, the right to keep and bear arms, the freedom from unreasonable searches and seizures, and so on. It is a rational continuum which, broadly speaking, includes a freedom from all substantial arbitrary impositions and purposeless restraints, and which also recognizes what a reasonable and sensitive judgment must, that certain interests require particularly careful scrutiny of the state needs asserted to justify their abridgment. Justice Harlan wrote these words in addressing an issue the full court did not reach in Poe v. Ullman, but the court adopted his position 4 terms later in Griswold v. Connecticut. In Griswold, we held that the Constitution does not permit a state to forbid a married couple to use contraceptives. That same freedom was later guaranteed under the Equal Protection Clause for unmarried couples. Constitutional protection was extended to the sale and distribution of contraceptives in Carey v. Population Services International. It is settled now, as it was when the court heard arguments in Roe v. Wade, that the Constitution places limits on a state's right to interfere with a person's most basic decisions about family and parenthood. See Carey v. Population Services International, Moore v. East Cleveland, Eisenstadt v. Baird, Loving v. Virginia, Griswold v. Connecticut, Skinner v. Oklahoma, Pierce v. Society of Sisters, Meyer v. Nebraska, as well as Bodily Integrity, and Washington v. Harper, Winston v. Lee, and Rochin v. California. The inescapable fact is that adjudication of substantive due process claims may call upon the court in interpreting the Constitution to exercise the same capacity which by tradition courts always have exercised, reasoned judgment. Its boundaries are not susceptible of expression as a simple rule. That does not mean we are free to invalidate state policy choices with which we disagree. Yet neither does it permit us to shrink from the duties of our office, as Justice Harlan observed. Due process has not been reduced to any formula. Its content cannot be determined by reference to any code. The best that can be said is that through the course of this court's decisions, it has represented the balance which our nation, built upon postulates of respect for the liberty of the individual, has struck between that liberty and the demands of organized society. If the supplying of content to this constitutional concept has of necessity been a rational process, it certainly has not been one where judges have felt free to roam where unguided speculation might take them. The balance of which I speak is the balance struck by this country having regard to what history teaches are the traditions from which it developed as well as the traditions from which it broke. That tradition is a living thing. A decision of this court which radically departs from it could not long survive, while a decision which builds on what has survived is likely to be sound. No formula could serve as a substitute in this area for judgment and restraint. See also Rochin v. California. To believe that this judicial exercise of judgment could be avoided by freezing due process of law at some fixed stage of time or thought is to suggest that the most important aspect of constitutional adjudication is a function for inanimate machines and not for judges. Men and women of good conscience can disagree, and we suppose some always shall disagree, about the profound moral and spiritual implications of terminating a pregnancy, even in its earliest stage. Some of us as individuals find abortion offensive to our most basic principles of morality, but that cannot control our decision. Our obligation is to define the liberty of all, not to mandate our own moral code. The underlying constitutional issue is whether the state can resolve these philosophic questions in such a definitive way that a woman lacks all choices in the matter, except perhaps in those rare circumstances in which the pregnancy is itself a danger to her own life or health, or is the result of rape or incest. It is a conventional constitutional doctrine that where reasonable people disagree, the government can adopt one position or the other. That theorem, however, assumes a state of affairs in which the choice does not intrude upon a protected liberty. Thus, while some people might disagree about whether or not the flag should be saluted or disagree about the proposition that it may not be defiled, we have ruled that a state may not compel or enforce one view or the other. Our law affords constitutional protection to personal decisions relating to marriage, procreation, contraception, family relationships, child rearing, and education. Our cases recognize the right of the individual, married or single, to be free from unwarranted governmental intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child. Our precedents have respected the private realm of family life which the state cannot enter. These matters, involving the most intimate and personal choices a person may make in a lifetime, choices central to personal dignity and autonomy, are central to the liberty protected by the 14th Amendment. At the heart of the liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. Beliefs about these matters could not define the attributes of personhood were they formed under compulsion of the state. These considerations begin our analysis of the woman's interest in terminating her pregnancy, but cannot end it. For this reason, though the abortion decision may originate within the zone of conscience and belief, it is more than a philosophic exercise. Abortion is a unique act. It is an act fraught with consequences for others, for the woman who must live with the implications of her decision, for the persons who perform and assist in the procedure, for the spouse, family, and society, which must confront the knowledge that these procedures exist. Procedures some deem nothing short of an act of violence against innocent human life, and depending on one's beliefs, for the life or potential life that is aborted. Though abortion is conduct, it does not follow that the state is entitled to proscribe it in all instances. That is because the liberty of the woman is at stake in a sense unique to the human condition and so unique to the law. The mother who carries a child to full term is subject to anxieties, to physical constraints, to pain that only she must bear. That these sacrifices have from the beginning of the human race been endured by women with a pride that ennobles her in the eyes of others and gives to the infant a bond of love cannot alone be grounds for the state to insist she make the sacrifice. Her suffering is too intimate and personal for the state to insist, without more, upon its own vision of the woman's role, however dominant that vision has been in the course of our history and our culture. The destiny of the woman must be shaped to a large extent on her own conception of her spiritual imperatives and her place in society. It should be recognized, moreover, that in some critical respects the abortion decision is of the same character as the decision to use contraception, to which Griswold v. Connecticut, Eisenstadt v. Barrett, and Carey v. Population Services International afford constitutional protection. We have no doubt as to the correctness of those decisions. They support the reasoning in Roe relating to the woman's liberty because they involve personal decisions concerning not only the meaning of procreation, but also human responsibility and respect for it. As with abortion, reasonable people will have differences of opinion about these matters. One view is based on such reverence for the wonder of creation that any pregnancy ought to be welcomed and carried to full term, no matter how difficult it will be to provide for the child and ensure its well-being. Another is that the inability to provide for the nurture and care of the infant is a cruelty to the child and an anguish to the parent. These are intimate views with infinite variations, and their deep personal character underlay our decisions in Griswold, Eisenstadt, and Carey. The same concerns are present when the woman confronts the reality that, perhaps despite her attempts to avoid it, she has become pregnant. It was this dimension of personal liberty that Roe sought to protect, and its holding invoked the reasoning and the tradition of the precedents we have discussed, granting protection to substantive liberties of the person. Roe was, of course, an extension of those cases, and as the decision itself indicated, the separate states could act in some degree to further their own legitimate interests in protecting prenatal life. The extent to which the legislatures of the states might act to outweigh the interests of the woman in choosing to terminate her pregnancy was a subject of debate both in Roe itself and in decisions following it. While we appreciate the weight of the arguments made on behalf of the state in the cases before us, arguments which in their ultimate formulation conclude that Roe should be overruled and the reservations any of us may have in reaffirming the central holding of Roe are outweighed by the explication of individual liberty we have given, combined with the force of stare decisis. We turn now to that doctrine. The obligation to follow precedent begins with necessity, and a contrary necessity marks its outer limit. With Cardozo, we recognize that no judicial system could do society's work if it eyed each issue afresh in every case that raised it. Indeed, the very concept of the rule of law underlying our own Constitution requires such continuity over time that a respect for precedent is, by definition, indispensable. At the other extreme, a different necessity would make itself felt if a prior judicial ruling should come to be seen so clearly as error that its enforcement was for that very reason doomed. Even when the decision to overrule a prior case is not, as in the rare latter instance, virtually foreordained, it is common wisdom that the rule of stare decisis is not an inexorable command, and certainly it is not such in every constitutional case. Rather, when this court re-examines a prior holding, its judgment is customarily informed by a series of prudential and pragmatic considerations designed to test the consistency of overruling a prior decision with the ideal of the rule of law, and to gauge the respective costs of reaffirming and overruling a prior case. Thus, for example, we may ask whether the rule has proven to be intolerable simply in defying practical workability. Whether the rule is subject to a kind of reliance that would lend a special hardship to the consequences of overruling and add inequity to the cost of repudiation. Whether related principles of law have so far developed as to have left the old rule no more than a remnant of abandoned doctrine. Or whether facts have so changed or come to be seen so differently as to have robbed the old rule of significant application or justification. So in this case, we may inquire whether Roe's central rule has been found unworkable, whether the rule's limitation on state power could be removed without serious inequity to those who have relied upon it, or significant damage to the stability of the society governed by it, whether the law's growth in the intervening years has left Roe's central rule a doctrinal anachronism discounted by society, and whether Roe's premises of fact have so far changed in the ensuing 2 decades as to render its central holding somehow irrelevant or unjustifiable in dealing with the issue it addressed. Although Roe has engendered opposition, it has in no sense proven unworkable, representing as it does a simple limitation beyond which a state law is unenforceable. While Roe has, of course, required judicial assessment of state laws affecting the exercise of the choice guaranteed against government infringement, and although the need for such review will remain as a consequence of today's decision, the required determinations fall within judicial competence. The inquiry into reliance counts the cost of a rule's repudiation as it would fall on those who have relied reasonably on the rule's continued application. Since the classic case for weighing reliance heavily in favor of following the earlier rule occurs in the commercial context, where advanced planning of great precision is most obviously a necessity, it is no cause for surprise that some would find no reliance worthy of consideration in support of Roe. While neither respondents nor their amici in so many words deny that the abortion right invites some reliance prior to its actual exercise, one can readily imagine an argument stressing the dissimilarity of this case to one involving property or contract. Abortion is customarily chosen as an unplanned response to the consequence of unplanned activity or to the failure of conventional birth control, and except on the assumption that no intercourse would have occurred but for Roe's holding. Such behavior may appear to justify no reliance claim. Even if reliance could be claimed on that unrealistic assumption, the argument might run any reliance interest would be de minimis. This argument would be premised on the hypothesis that reproductive planning could take virtually immediate account of any sudden restoration of state authority to ban abortions. To eliminate the issue of reliance that easily, however, one would need to limit cognizable reliance of specific instances of sexual activity. But to do this would be simply to refuse to face the fact that for 2 decades of economic and social developments, people have organized intimate relationships and made choices that define their views of themselves and their places in society, in reliance on the availability of abortion in the event that contraception should fail. The ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives. The Constitution serves human values, and while the effect of reliance on Roe cannot be exactly measured, neither can the certain cost of overruling Roe for people who have ordered their thinking and living around that case be dismissed. No evolution of legal principle has left Roe's doctrinal footing weaker than they were in 1973. No development of constitutional law since the case was decided has implicitly or explicitly left Roe behind as a mere survivor of obsolete constitutional thinking. It will be recognized, of course, that Roe stands at an intersection of 2 lines of decisions, but in whichever doctrinal category one reads the case, the result for present purposes will be the same. The Roe Court placed its holding in the succession of cases most prominently exemplified by Griswold v. Connecticut. When it is so seen, Roe is clearly in no jeopardy since subsequent constitutional developments have neither disturbed nor do they threaten to diminish the scope of recognized protection accorded to the liberty relating to intimate relationships, the family, and decisions about whether or not to beget or bear a child. Roe, however, may be seen not only as an exemplar of Griswold liberty, but as a rule, whether or not mistaken, of personal autonomy and bodily integrity, with doctrinal affinity to cases recognizing limits on governmental power to mandate medical treatment or to bar its rejection. If so, our cases since Roe accord with Roe's view that a state's interest in the protection of life falls short of justifying any plenary override of individual liberty claims. Finally, one could classify Roe as sui generis. If the case is so viewed, then there clearly has been no erosion of its central determination. The original holding, resting on the concurrence of 7 members of the court in 1973, was expressly affirmed by a majority of 6 in 1983. See Akron versus Akron Center for Reproductive Health. And by a majority of 5 in 1986. See Thornburg versus American College of Obstetricians and Gynecologists. Expressing adherence to the constitutional ruling despite legislative efforts in some states to test its limits. More recently, in Webster v. Reproductive Health Services, although 2 of the present authors questioned the trimester framework in a way consistent with our judgment today, a majority of the court either decided to reaffirm or decline to address the constitutional validity of the central holding of Roe. Nor will courts building upon Roe be likely to hand down erroneous decisions as a consequence. Even on the assumption that the central holding of Roe was an error, that error would go only to the strength of the state interest in fetal protection, not to the recognition afforded by the Constitution to the woman's liberty. The latter aspect of the decision fits comfortably within the framework of the court's prior decisions, including Skinner v. Oklahoma, Griswold, Loving v. Virginia, Eisenstadt v. Baird, the holdings of which are not a series of isolated points but mark a rational continuum, citing Poe v. Ullman. As we described in Carey v. Population Services International, the liberty which encompasses those decisions includes the interest in independence in making certain kinds of important decisions. While the outer limits of this aspect are protected liberty have not been marked by the court, it is clear that among the decisions that an individual may make without unjustified government interference are personal decisions relating to marriage, procreation, contraception, family relationships, and child rearing and education. The soundness of this prong of the Roe analysis is apparent from the consideration of the alternative. If indeed the woman's interest in recognizing whether to bear and beget a child has not been recognized as in Roe, the state might as readily restrict a woman's right to choose to carry a pregnancy to term as to terminate it, to further assert its state interest in population control or eugenics, for example. Yet Roe has been sensibly relied upon to counter any such suggestions. See, for example, Arnold v. Board of Education of Escambia County, relying upon Roe and concluding that the government officials violate the Constitution by coercing a minor to have an abortion. Avery v. County of Burke, county agency inducing teenage girl to undergo unwanted sterilization on the basis of misrepresentation that she had sickle cell trait. See also Inri Quinlan, relying on Roe in finding a right to terminate medical treatment. Denied Gardner v. New Jersey. In any event, because Roe's scope is confined by the fact of its concern with post-conception potential life, a concern otherwise likely to be implicated only by some forms of contraception protected independently under Griswold and later cases, any error in Roe is unlikely to have serious ramifications in future cases. We have seen how time has overtaken some of Roe's factual assumptions. Advances in maternal health care allow for abortions safe to the mother later in pregnancy than was true in 1973, and advances in neonatal care have advanced viability to a point somewhat earlier. But these facts go only to the scheme of time limits on the realization of competing interests, and the divergence from the factual premises of 1973 have no bearing on the validity of Roe's central holding. That viability marks the earliest point at which the state's interest in fetal life is constitutionally adequate to justify a legislative ban on non-therapeutic abortions. The soundness or unsoundness of that constitutional judgment in no sense turns on whether viability occurs at approximately 28 weeks. As was usual at the time of Roe, at 23 to 24 weeks, as it sometimes does today, or at some moment even slightly earlier in pregnancy, as it may if fetal respiratory capacity can somehow be enhanced in the future. Whenever it may occur, the attainment of viability may continue to serve as a critical fact, just as it has done since Roe was decided, which is to say that no change in Roe's factual underpinnings has left its central holding obsolete, and none supports an argument for overruling it. The sum of the precedential inquiry to this point shows Roe's underpinnings unweakened in any way affecting its central holding. While it has engendered disapproval, it has not been unworkable. An entire generation has come of age free to assume Roe's concept of liberty in defining the capacity of women to act in society and to make reproductive decisions. No erosion of principle going to liberty or personal autonomy has left Roe's central holding a doctrinal remnant. Roe portends no developments at odds with other precedent for the analysis of personal liberty, and no changes of fact have rendered viability more or less appropriate as the point at which the balance of interest tips. Within the bounds of normal stare decisis analysis, then, and subject to the considerations on which it customarily turns, the stronger argument is for affirming Roe's central holding with whatever degree of personal reluctance any of us may have, not for overruling it. In a less significant case, stare decisis analysis could, and would, stop at the point we have reached. But the sustained and widespread debate Roe has provoked calls for some comparison between that case and others of comparable dimension, that have responded to national controversies and taken on the impress of the controversies addressed. Only two such decisional lines from the past century present themselves for examination, and in each instance the result reached by the court accorded with the principles we apply today. The first example is that line of cases identified with Lochner v. New York, which imposed substantive limitations on legislation limiting economic autonomy in favor of health and welfare regulation, adopting, in Justice Holmes' view, the theory of laissez-faire. The Lochner decisions were exemplified by Atkins v. Children's Hospital of District of Columbia, in which the court held it to be an infringement of constitutionally protected liberty of contract to require the employer of adult women to satisfy minimum wage standards. 14 years later, West Coast Hotel Company v. Parrish signaled the demise of Lochner by overruling Atkins. In the meantime, the Depression had come, and with it, the lesson that seemed unmistakable to most people by 1937, that the interpretation of contractual freedom protected in Atkins rested on fundamentally false factual assumptions about the capacity of a relatively unregulated market to satisfy minimum levels of human welfare. As Justice Jackson wrote of the constitutional crisis of 1937 shortly before he came on the bench, the older world of laissez-faire was recognized everywhere outside the court to be dead. The facts upon which the earlier case had premised a constitutional resolution of social controversy had proven to be untrue, and history's demonstration of their untruth not only justified but required the new choice of constitutional principle that West Coast Hotel announced. Of course, it was true that the court lost something by its misperception, or its lack of prescience, and the court packing crisis only magnified the loss, but the clear demonstration that the facts of economic life were different from those previously assumed warranted the repudiation of the old law. The second comparison that 20th century history invites is with the cases employing the separate but equal rule for applying the 14th Amendment's equal protection guarantee. They began with Plessy v. Ferguson, holding that legislatively mandated racial segregation in public transportation works no denial of equal protection, rejecting the argument that racial separation enforced by the legal machinery of American society treats the black race as inferior. The Plessy court considered the underlying fallacy of the plaintiff's argument to consist in the assumption that the enforced separation of the two races stamps the colored race with a badge of inferiority. If this be so, it is not by reason of anything found in the act, but solely because the colored race chooses to put that construction upon it. Whether as a matter of historical fact the justices in the Plessy majority believed this or not, this understanding of the implication of segregation was the stated justification for the court's opinion. But this understanding of the facts and the rule it was stated to justify were repudiated in Brown v. Board of Education. As one commentator observed, the question before the court in Brown was whether discrimination inheres in that segregation which is imposed by law in the 20th century in certain specific states in the American Union. And that question has meaning and can find an answer only on the ground of history and of common knowledge about the facts of life in the times and places aforesaid. The court in Brown addressed these facts of life by observing that whatever may have been the understanding in Plessy's time of the power of segregation to stigmatize those who were segregated by a badge of inferiority, it was clear by 1954 that legally sanctioned segregation had just such an effect, to the point that racially separate public educational facilities were deemed inherently unequal. Society's understanding of the facts upon which a constitutional ruling was sought in 1954 was thus fundamentally different from the basis claimed for the decision in 1896. While we think Plessy was wrong the day it was decided, we must also recognize that the Plessy court's explanation for its decision was so clearly at odds with the facts apparent to the court in 1954 that the decision to re-examine Plessy was on this ground alone not only justified but required. West Coast Hotel and Brown each rested on facts or an understanding of the facts changed from those which furnished the claimed justifications for the earlier constitutional resolutions. Each case was comprehensible as the court's response to facts that the country could understand or had come to understand already, but which the court of an earlier day, as its own declarations disclosed, had not been able to perceive. As the decisions were thus comprehensible, they were also defensible, not merely as the victories of one doctrinal school over another, by dint of numbers, victories though they were, but as applications of constitutional principle to facts as they had not been seen by the court before. In constitutional adjudication, as elsewhere in life, changed circumstances may impose new obligations, and the thoughtful part of the nation could accept each decision to overrule a prior case as a response to the court's constitutional duty. Because the cases before us present no such occasion, Because the cases before us present no such occasion, it could be seen as no such response. Because neither the factual underpinnings of Roe's central holding nor our understanding of it has changed, and because no other indication of weakened precedent has been shown, the court could not pretend to be re-examining the prior law with any justification beyond the present doctrinal disposition to come out differently from the court of 1973. To overrule prior law for no other reason than that would run counter to the view repeated in our cases, that a decision to overrule must rest on some special reason over and above the belief that a prior case was wrongly decided. Mitchell versus W.T. Grant. A basic change in the law upon a ground no firmer than a change in our membership invites the popular misconception that this institution is little different from the two political branches of the government. No misconception could do more lasting injury to this court and to the system of law which it is our abiding mission to serve. The examination of the conditions justifying the repudiation of Atkins by West Coast Hotel and Plessy by Brown is enough to suggest the terrible price that would have been paid if the court had not overruled as it did. In the present cases, however, as our analysis to this point makes clear, the terrible price would be paid for overruling. Our analysis would not be complete, however, without explaining why overruling Roe's central holding would not only reach an unjustifiable result under principles of stare decisis, but would seriously weaken the court's capacity to exercise the judicial power and to function as the Supreme Court of a nation dedicated to the rule of law. To understand why this would be so, it is necessary to understand the source of this court's authority, the conditions necessary for its preservation, and its relationship to the country's understanding of itself as a constitutional republic. The root of American governmental power is revealed most clearly in the instance of the power conferred by the Constitution upon the judiciary of the United States, and specifically upon this court. As Americans of each succeeding generation are rightly told, the court cannot buy support for its decisions by spending money and, except to a minor degree, it cannot independently coerce obedience to its decrees. The court's power lies rather in its legitimacy, a product of substance and perception that shows itself in the people's acceptance of the judiciary as fit to determine what the nation's law means and to declare what it demands. The underlying substance of this legitimacy is, of course, the warrant for the court's decisions in the Constitution and the lesser sources of legal principle on which the court draws. That substance is expressed in the court's opinions, and our contemporary understanding is such that a decision without principal justification would be no judicial act at all. But even when justification is furnished by apposite legal principle, something more is required. Because not every conscientious claim of principal justification will be accepted as such, the justification claimed must be beyond dispute. The court must take care to speak and act in ways that allow people to accept its decisions on the terms the court claims for them, as grounded truly in principle, not as compromises with social and political pressures having, as such, no bearing on the principled choices that the court is obliged to make. Thus, the court's legitimacy depends on making legally principled decisions under circumstances in which their principled character is sufficiently plausible to be accepted by the nation. The need for principled action to be perceived as such is implicated to some degree whenever this or any other appellate court overrules a prior case. This is not to say, of course, that this court cannot give a perfectly satisfactory explanation in most cases. People understand that some of the Constitution's language is hard to fathom, and that the court's justices are sometimes able to perceive significant facts or to understand principles of law that eluded their predecessors and that justify departures from existing decisions. However upsetting it may be to those most directly affected when one judicially derived rule replaces another, the country can accept some correction of error without necessarily questioning the legitimacy of the court. In two circumstances, however, the court would almost certainly fail to receive the benefit of the doubt in overruling prior cases. There is first a point beyond which frequent overruling would overtax the country's belief in the court's good faith. Despite the variety of reasons that may inform a just and justify a decision to overrule, we cannot forget that such a decision is usually perceived, and perceived correctly, as at the least a statement that a prior decision was wrong. There is a limit to the amount of error that can plausibly be imputed to prior courts. If that limit should be exceeded, disturbance of prior rulings would be taken as evidence that justifiable re-examination of principle had given way to drives for particular results in the short term. The legitimacy of the court would fade with the frequency of its vacillation. That first circumstance can be described as hypothetical. The second is to the point here and now, where in the performance of its judicial duties, the court decides a case in such a way as to resolve the sort of intensely divisive controversy reflected in Roe and those rare comparable cases. Its decision has a dimension that the resolution of the normal case does not carry. It is the dimension present whenever the court's interpretation of the Constitution calls the contending sides of a national controversy to end their national division by accepting a common mandate rooted in the Constitution. The court is not asked to do this very often, having thus addressed the nation only twice in our lifetime in the decisions of Brown and Roe. But when the court does act in this way, its decisions requires an equally rare presidential force to counter the inevitable efforts to overturn it and to thwart its implementation. Some of those efforts may be merely unprincipled emotional reactions. Others may proceed from principles worthy of profound respect. But whatever the premises of opposition may be, only the most convincing justification under accepted standards of precedent could suffice to demonstrate that a later decision overruling the first was anything but a surrender to political pressure and an unjustified repudiation of the principle on which the court staked its authority in the first instance. So to overrule under fire in the absence of the most compelling reason to re-examine a watershed decision would subvert the court's legitimacy beyond any serious question. Citing Brown v. Board of Education, it should go without saying that the vitality of the constitutional principles announced in Brown 1, this is Brown 2, quoting Brown 1. It should go without saying that the vitality of the constitutional principles announced in Brown 1 cannot be allowed to yield simply because of disagreement with them. The country's loss of confidence in the judiciary would be underscored by an equally certain and equally reasonable condemnation for another failing in overruling unnecessarily and under pressure. Some costs will be paid by anyone who approves or implements a constitutional decision where it is unpopular, or who refuses to work to undermine the decision or to force its reversal. The price may be criticism or ostracism, or it may be violence. An extra price will be paid by those who themselves disapprove of the decision's results when viewed outside of constitutional terms, but who nevertheless struggle to accept it. Because they respect the rule of law, to all those who will be so tested by following, the court implicitly undertakes to remain steadfast, lest in the end a price be paid for nothing. The promise of constancy once given binds its maker for as long as the power to stand by the decision survives, and the understanding of the issue has not changed so fundamentally as to render the commitment obsolete. From the obligation of this promise, this court cannot and should not assume any exemption when duty requires it to decide a case in conformance with the Constitution. A willing breach of it would be nothing less than a breach of faith, and no court that broke its faith with the people could sensibly expect credit for a principle in the decision by which it did that. It is true that diminished legitimacy may be restored, but only slowly. Unlike the political branches, a court thus weakened could not seek to regain its position with a new mandate from the voters, and even if the court could somehow go to the polls, the loss of its principled character could not be retrieved by the casting of so many votes. Like the character of an individual, the legitimacy of the court must be earned over time. So indeed must the character of a nation of people who aspire to live according to the rule of law. Their belief in themselves as such a people is not readily separable from their understanding of the court invested with the authority to decide their constitutional cases and speak before all others for their constitutional ideals. If the court's legitimacy should be undermined, then so would the country be in its very ability to see itself through its constitutional ideals. The court's concern with legitimacy is not for the sake of the court, but for the sake of the nation to which it is responsible. The court's duty in the present cases is clear. In 1973, it confronted the already divisive issue of governmental power to limit personal choice to undergo abortion, for which it provided a new resolution based on the Due Process Clause guaranteed by the 14th Amendment. Whether or not a new social consensus is developing on that issue, its divisiveness is no less today than in 1973, and pressure to overrule the decision, like pressure to retain it, has grown only more intense. A decision to overrule Roe's essential holding under the existing circumstances would address error. If error there was, at the cost of both profound and unnecessary damage to the court's legitimacy and to the nation's commitment to the rule of law. It is therefore imperative to adhere to the essence of Roe's original decision, and we do so today. From what we have said so far, it follows that it is a constitutional liberty of the woman to have some freedom to terminate her pregnancy. We conclude that the basic decision in Roe was based on the constitutional analysis which we cannot now repudiate. The woman's liberty is not so unlimited, however, that from the outset the state cannot show its concern for the life of the unborn, and at a later point in fetal development, the state's interest in life as sufficient force so that the right of the woman to terminate the pregnancy can be restricted. That brings us, of course, to the point where much criticism has been directed at Roe, a criticism that always adheres when the court draws a specific rule from what in the Constitution is but a general standard. We conclude, however, that the urgent claims of the woman to retain the ultimate control over her destiny and her body, claims implicit in the meaning of liberty, require us to perform that function. Liberty must not be extinguished for want of a line that is clear, and it falls to us to give some real substance to the woman's liberty to determine whether to carry her pregnancy to full term. We conclude the line should be drawn at viability, so that before that time the woman has a right to choose to terminate her pregnancy. We adhere to this principle for two reasons. First, as we have said, is the doctrine of stare decisis. Any judicial act of line drawing may seem somewhat arbitrary, but Roe was a reasoned statement elaborated with great care. We have twice reaffirmed it in the face of great opposition. Although we must overrule those parts of Thornburg and Akron 1, which in our view are inconsistent with Roe's statement that the state has a legitimate interest in promoting the life or potential life of the unborn, the central premise of those cases represents an unbroken commitment by this court to the essential holding of Roe. It is that premise which we reaffirm today. The second reason is that the concept of viability, as we noted in Roe, is the time at which there is a realistic possibility of maintaining and nourishing a life outside the womb, so that the independent existence of the second life can in reason and all fairness be the object of state protection that now overrides the rights of the woman. Consistent with other constitutional norms, legislatures may draw lines which appear arbitrary without the necessity of offering a justification, but courts may not. We must justify the lines we draw, and there is no line other than viability which is more workable. To be sure, as we have said, there may be some medical developments that affect the precise point of viability, but this is an imprecision within tolerable limits, given that the medical community and all those who must apply its discoveries will continue to explore the matter. The viability line also has, as a practical matter, an element of fairness. In some broad sense, it might be said that a woman who fails to act before viability has consented to the state's intervention on behalf of the developing child. The woman's right to terminate her pregnancy before viability is the most central principle of Roe v. Wade. It is a rule of law and a component of liberty we cannot renounce. On the other side of the equation is the interest of the state in the protection of potential life. The Roe court recognized the state's important and legitimate interest in protecting the potentiality of human life. The weight to be given this state interest, not the strength of the woman's interest, was the difficult question faced in Roe. We do not need to say whether each of us had we been members of the court when the valuation of the state interest came before it as an original matter, would have concluded, as the Roe court did, that its weight is insufficient to justify a ban on abortions prior to viability, even when it is subject to certain exceptions. The matter is not before us in the first instance, and coming as it does after nearly 20 years of litigation in Roe's wake, we are satisfied that the immediate question is not the soundness of Roe's resolution of the issue, but the precedential force that must be accorded to its holding. And we have concluded that the essential holding of Roe should be reaffirmed. Yet it must be remembered that Roe v. Wade speaks with clarity in establishing not only the woman's liberty, but also the state's important and legitimate interest in potential life. That portion of the decision in Roe has been given too little acknowledgement and implementation by the court in its subsequent cases. Those cases decided that any regulation touching upon the abortion decision must survive strict scrutiny to be sustained only if drawn in narrow terms to further a compelling state interest. Not all of the cases decided under the formulation can be reconciled with the holding in Roe itself that the state has legitimate interests in the health of the woman and in protecting the potential life within her. In resolving this tension, we choose to rely upon Roe, as against the later cases. Roe established a trimester framework to govern abortion regulations. Under this elaborate but rigid construct, almost no regulation at all is permitted during the first trimester of pregnancy. Regulations designed to protect the woman's health, but not to further the state's interest in potential life, are permitted during the second trimester. And during the third trimester, when the fetus is viable, prohibitions are permitted provided the life or health of the mother is not at stake. Most of our decisions since Roe have involved the application of rules derived from the trimester framework. The trimester framework was no doubt was erected to ensure that the woman's right to choose not become so subordinate to the state's interest in promoting fetal life that her choice exists in theory but not in fact. We do not agree, however, that the trimester approach is necessary to accomplish this objective. A framework of this rigidity was unnecessary and, in its later interpretation, sometimes contradicted the state's permissible exercise of its powers. Though the woman has a right to choose to terminate or continue her pregnancy before viability, it does not at all follow that the state is prohibited from taking steps to ensure that this choice is thoughtful and informed. Even in the earliest stages of pregnancy, the state may enact rules and regulations designed to encourage her to know that there are philosophic and social arguments of great weight that can be brought to bear in favor of continuing the pregnancy to full term, and that there are procedures and institutions to allow adoption of unwanted children, as well as a certain degree of state assistance if the mother chooses to raise the child herself. The Constitution does not forbid a state or city pursuant to democratic processes from expressing a preference for normal childbirth. It follows that states are free to enact laws to provide a reasonable framework for a woman to make a decision that has such profound and lasting meaning. This, too, we find consistent with Roe's central premises, and indeed the inevitable consequence of our holding, that the state has an interest in protecting the life of the unborn. We reject the trimester framework, which we do not consider to be part of the central holding of Roe. Describing the trimester, quoting Justice O'Connor, concurring in part and dissenting in part, measures aimed at ensuring that a woman's choice contemplates the consequences for the fetus do not necessarily interfere with the right recognized in Roe. Although those measures have been found to be inconsistent with the rigid trimester framework announced in that case, a logical reading of the central holding in Roe itself and a necessary reconciliation of the liberty of the woman and the interest of the state in promoting prenatal life require, in our view, that we abandon the trimester framework as a rigid prohibition on all pre-viability regulation aimed at the protection of fetal life. The trimester framework suffers from these basic flaws. In its formulation, it misconceives the nature of the pregnant woman's interest, and in practice it undervalues the state's interest in potential life, as recognized in Roe. As our jurisprudence relating to all liberties, save perhaps abortion, has recognized, not every law which makes a right more difficult to exercise is, ipso facto, an infringement on that right. An example clarifies the point. We have held that not every ballot access limitation amounts to an infringement of the right to vote. Rather, the states are granted substantial flexibility in establishing the framework, within which voters choose the candidates for whom they wish to vote. The abortion right is similar. Numerous forms of state regulation might have the incidental effect of increasing the cost or decreasing the availability of medical care, whether for abortion or any other medical procedure. The fact that a law which serves a valid purpose, one not designed to strike at the right itself, has the incidental effect of making it more difficult or more expensive to procure an abortion cannot be enough to invalidate it. Only where state regulation imposes an undue burden on a woman's ability to make this decision does the power of the state reach into the heart of the liberty protected by the Due Process Clause. For the most part, the court's early abortion cases adhered to this view. In Marr v. Roe, the court explained, Roe did not declare an unqualified constitutional right to an abortion, as the district courts seemed to think. Rather, the right protects the woman from unduly burdensome interference with her freedom to decide whether to terminate her pregnancy. See also Doe v. Bolton. The interposition of the hospital abortion committee is unduly restrictive of the patient's right. Bellotti 1, states may not impose undue burdens upon a minor capable of giving an informed consent. Harris v. McCrae citing, and then Carey v. Population Services International. The same test must be applied to state regulations that burden an individual's right to decide to prevent conception or terminate pregnancy by substantially limiting access to the means of effectuating that decision as it applied to state statutes that prohibit the decision entirely. These considerations of the nature of the abortion right illustrate that it is an overstatement to describe it as a right to decide whether to have an abortion without interference from the state. All abortion regulations interfere to some degree with a woman's ability to decide whether to terminate her pregnancy. It is, as a consequence, not surprising that despite the protestations contained in the original Roe opinion to the effect that the court was not recognizing an absolute right, the court's experience applying the trimester framework has led to the striking down of some abortion regulations which in no real sense deprived women of the ultimate decision. Those decisions went too far because the right recognized by Roe is a right to be free from unwarranted governmental intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child. Not all governmental intrusion is of necessity unwarranted, and that brings us to the other basic flaw in the trimester framework. Even in Roe's terms, in practice, it undervalues the state's interest in the potential life within the woman. Roe v. Wade was expressed in its recognition of the state's important and legitimate interests in preserving and protecting the health of the pregnant woman and in protecting the potentiality of human life. The trimester framework, however, does not fulfill Roe's own promise that the state has an interest in protecting fetal life or potential life. Roe began the contradiction by using the trimester framework to forbid any regulation of abortion designed to advance that interest before viability. Before viability, Roe and subsequent cases treated all governmental attempts to influence a woman's decision on behalf of the potential life within her as unwarranted. This treatment is, in our judgment, incompatible with the recognition that there is a substantial state interest in potential life throughout pregnancy. The very notion that the state has a substantial interest in potential life leads to the conclusion that not all regulations must be deemed unwarranted. Not all burdens on the right to decide whether to terminate a pregnancy will be undue. In our view, the undue burden standard is the appropriate means of reconciling the state's interest with the woman's constitutionally protected liberty. The concept of an undue burden has been utilized by the court as well as individual members of the court, including two of us, in ways that would be considered inconsistent. Because we set forth a standard of general application to which we intend to adhere, it is important to clarify what is meant by an undue burden. A finding of an undue burden is a shorthand for the conclusion that a state regulation has the purpose or effect of placing a substantial obstacle in the path of a woman seeking an abortion of a non-viable fetus. A statute with this purpose is invalid because the means chosen by the state to further the interest in potential life must be calculated to inform the woman's free choice, not hinder it. And a statute which, while furthering the interest in potential life or some other valid state interest, has the effect of placing a substantial obstacle in the path of a woman's choice cannot be considered a permissible means of serving its legitimate ends. To the extent that the opinions of the court or of individual justices use the undue burden standard in a manner that is inconsistent with this analysis, we set out what in our view should be the controlling standard. Quoting McCleskey v. Zant, attempting to define the doctrine of abuse of the writ with more precision after acknowledging tension among earlier cases. In our considered judgment, an undue burden is an unconstitutional burden. Understood another way, we answer the question left open in previous opinions discussing the undue burden formulation. Whether a law designed to further the state's interest in fetal life, which imposes an undue burden on the woman's decision before fetal viability, could be constitutional. The answer is no. Some guiding principles should emerge. What is at stake is the woman's right to make the ultimate decision, not a right to be insulated from all others in doing so. Regulations which do no more than create a structural mechanism by which the state or the parent or guardian of a minor may express profound respect for the life of the unborn are permitted, if they are not a substantial obstacle to the woman's exercise of the right to choose. Unless it has that effect on her right of choice, a state measure designed to persuade her to choose childbirth over abortion will be upheld if reasonably related to that goal. Regulations designed to foster the health of a mother seeking an abortion are valid if they do not constitute an undue burden. Even when jurists reasons from shared premises, some disagreement is inevitable. Compare Hodgson. Compare Hodgson, Kennedy concurring apart and dissenting apart with this, concurring apart and dissenting apart. That is to be expected in the application of any legal standard which must accommodate life's complexity. We do not expect it to be otherwise with respect to the undue burden standard. We give this summary. To protect the central right recognized by Roe v. Wade while at the same time accommodating the state's profound interest in potential life, we will employ the undue burden analysis as explained in this opinion. An undue burden exists, and therefore a provision of law is invalid if its purpose or effect is to place a substantial obstacle in the path of a woman seeking an abortion before the fetus attains viability. We reject the rigid trimester framework of Roe v. Wade. To promote the state's profound interest in potential life throughout pregnancy, the state may take measures to ensure that the woman's choice is informed, and measures designed to advance this interest will not be invalidated as long as their purpose is to persuade the woman to choose childbirth over abortion. These measures must not be an undue burden on the right. As with any medical procedure, the state may enact regulations to further the health or safety of a woman seeking an abortion. Unnecessary health regulations that have the purpose or effect of presenting a substantial obstacle to a woman seeking an abortion impose an undue burden on the right. Our adoption of the undue burden analysis does not disturb the central holding of Roe, and we reaffirm that holding. Regardless of whether exceptions are made for particular circumstances, a state may not prohibit any woman from making the ultimate decision to terminate her pregnancy before viability. We also reaffirm Roe's holding that subsequent to viability, the state, in promoting its interest in the potentiality of human life, may, if it chooses, regulate or even proscribe abortion, except where it is necessary in appropriate medical judgment for the preservation of the life or health of the mother. These principles control our assessment of the Pennsylvania statute, and we now turn to the issue of validity of its challenged provisions. The Court of Appeals applied what it believed to be the undue burden standard and upheld each of the provisions except for the husband notification requirement. We agree generally with this conclusion, but refine the undue burden analysis in accordance with the principles articulated above. We now consider the separate statutory sections at issue. Because it is central to the operation of various other requirements, we begin with the statute's definition of medical emergency. Under the statute, a medical emergency is that condition which, on the basis of the physician's good faith clinical judgment, so complicates the medical condition of a pregnant woman as to necessitate the immediate abortion of her pregnancy to avert her death, or for which a delay will create serious risk of substantial and irreversible impairment of a major bodily function. Petitioners argue that the definition is too narrow, contending that it forecloses the possibility of an Petitioners argue that the definition is too narrow, contending that it forecloses the possibility of an immediate abortion despite some significant health risks. If the contention were correct, we would be required to invalidate the restrictive operation of the provision, for the essential holding of Roe forbids a state to interfere with a woman's choice to undergo an abortion procedure if continuing her pregnancy would constitute a threat to her health. The district court found that there were three serious conditions which would not be covered by the statute: preeclampsia, inevitable abortion, and premature ruptured membrane. Yet, as the Court of Appeals observed, it is undisputed that under some circumstances, each of these conditions could lead to an illness with substantial and irreversible consequences. While the definition could be interpreted in an unconstitutional manner, the Court of Appeals construed the phrase serious risk to include those circumstances. It stated, "We read the medical emergency exception as intended by the Pennsylvania legislature to assure that compliance with its abortion regulations would not in any way pose a significant threat to the life or health of a woman. Normally, we defer to the construction of a state statute, as we said in Brockett v. Spokane Arcades Incorporated. Normally, we defer to the construction of a state statute given it by the lower federal courts. Indeed, we have said that we will defer to lower court interpretations of state law unless they amount to plain error. This reflects our belief that district courts and courts of appeals are better schooled in and more able to interpret the laws of their respective states. We adhere to that course today, and conclude that, as construed by the Court of Appeals, the medical emergency definition imposes no undue burden on a woman's abortion right. We next consider the informed consent requirement. Except in a medical emergency, the statute requires that at least 24 hours before performing an abortion, a physician inform the woman of the nature of the procedure, the health risks of the abortion and of childbirth, and the probable gestational age of the unborn child. The physician or a qualified non-physician must inform the woman of the availability of printed materials published by the state describing the fetus and providing information about medical assistance for childbirth, information about child support from the father, and a list of agencies which provide adoption and other services as alternatives to abortion. An abortion may not be performed unless the woman certifies in writing that she has been informed of the availability of these printed materials and has been provided them if she chooses to view them. Our prior decisions established that, as with any medical procedure, the state may require a woman to give her written informed consent to an abortion. In this respect, the statute is unexceptional. Petitioners challenge the statute's definition of informed consent because it includes the provision of specific information by the doctor and the mandatory 24-hour waiting period. The conclusions reached by a majority of the justices in the separate opinions filed today and the undue burden standard adopted in this opinion require us to overrule in part some of the court's past decisions driven by the trimester framework's prohibition of all pre-viability regulations designed to further the state's interest in fetal life. In Akron 1, we invalidated an ordinance which required that a woman seeking an abortion be provided by her physician with specific information designed to influence the woman's informed choice between abortion or childbirth. As we later described, the Akron 1 holding in Thornburg versus American College of Obstetricians and Gynecologists, there were two purported flaws in the Akron Ordinance. The information was designed to dissuade the woman from having an abortion, and the ordinance imposed a rigid requirement that a specific body of information be given in all cases, irrespective of the particular needs of the patient. To the extent Akron 1 and Thornburg find a constitutional violation when the government requires, as it does here, the giving of truthful, non-misleading information about the nature of the procedure, the attendant health risks and those of childbirth, and the probable gestational age of the fetus, those cases go too far, are inconsistent with Roe's acknowledgement of an important interest in potential life, and are overruled. This is clear even on the very terms of Akron 1 and Thornburg. Those decisions, along with Danforth, recognize a substantial government interest justifying a requirement that a woman be apprised of the health risks of abortion and childbirth. It cannot be questioned that psychological well-being is a facet of health, nor can it be doubted that most women considering an abortion would deem the impact on the fetus relevant, if not dispositive, to the decision. In attempting to ensure that a woman apprehend the full consequences of her decision, the state furthers the legitimate purpose of reducing the risk that a woman may elect an abortion only to discover later, with devastating psychological consequences, that her decision was not fully informed. If the information the state requires to be made available to the woman is truthful and not misleading, the requirement may be permissible. We also see no reason why the state may not require doctors to inform a woman seeking an abortion of the availability of materials relating to the consequences to the fetus, even when those consequences have no direct relation to her health. An example illustrates the point. We would think it constitutional for the state to require that in order for there to be informed consent to a kidney transplant operation, the recipient must be supplied with information about risks to the donor as well as risks to himself or herself. A requirement that the physician make available information similar to that mandated by the statute here was described in Thornburg as an outright attempt to wedge the Commonwealth's message discouraging abortion into the privacy of the informed consent dialogue between the woman and her physician. We conclude, however, that informed choice need not be defined in such narrow terms, that all considerations of the effect on the fetus are made irrelevant. As we have made clear, we depart from the holdings of Akron 1 and Thornburg, to the extent that we permit a state to further its legitimate goal of protecting the life of the unborn by enacting legislation aimed at ensuring a decision that is mature and informed, even when in so doing the state expresses a preference for childbirth over abortion. In short, requiring that the woman be informed of the availability of information relating to fetal development and the assistance available should she decide to carry the pregnancy to full term is a reasonable measure to ensure an informed choice, one which that might cause the woman to choose childbirth over abortion. This requirement cannot be considered a substantial obstacle to obtaining an abortion, and it follows there is no undue burden. Our prior cases also suggest that the straitjacket of particular information, which must be given in each case, interferes with a constitutional right of privacy between a pregnant woman and her physician. As a preliminary matter, it is worth noting that the statute now before us does not require a physician to comply with the informed consent provisions if he or she can demonstrate by a preponderance of the evidence that he or she reasonably believed that furnishing the information would have resulted in a severely adverse effect on the physical or mental health of the patient. In this respect, the statute does not prevent the physician from exercising his or her medical judgment. Whatever constitutional status the doctor-patient relation may have, as a general matter, in the present context, it is derivative of the woman's position. The doctor-patient relation does not underlie or override the two more general rights under which the abortion right is justified: the right to make family decisions and the right to physical autonomy. On its own, the doctor-patient relation here is entitled to the same solicitude it receives in other contexts. Thus, a requirement that a doctor give a woman certain information as part of obtaining her consent to an abortion is, for constitutional purposes, no different from a requirement that a doctor gives certain specific information about any medical procedure. All that is left of petitioner's argument is an asserted First Amendment right of a physician not to provide information about the risks of abortion and childbirth in a manner mandated by the state. To be sure, the physician's First Amendment rights not to speak are implicated, but only as part of the practice of medicine, subject to reasonable licensing and regulation by the state. We see no constitutional infirmity in the requirement that a physician provide the information mandated by the state here. The Pennsylvania statute also requires us to reconsider the holding in Akron 1, and the state may not require that a physician, as opposed to a qualified assistant, provide information relevant to a woman's informed consent. Since there is no evidence on this record that requiring a doctor to give the information as provided by the statute would amount, in practical terms, to a substantial obstacle to a woman seeking an abortion, we conclude that it is not an undue burden. Our cases reflect the fact that the Constitution gives the states broad latitude to decide that particular functions may be performed only by licensed professionals, even if an objective assessment might suggest that those same tasks could be performed by others. Thus, we uphold the provision as a reasonable means to ensure that the woman's consent is informed. Our analysis in Pennsylvania's 24-hour waiting period between the provision of the information deemed necessary to informed consent and the performance of an abortion under the undue burden standard requires us to consider the premise behind the decision in Akron 1, invalidating a parallel requirement. In Akron 1, we said, "Nor are we convinced that the state's legitimate concern that the woman's decision be informed is reasonably served by requiring a 24-hour delay as a matter of course." We consider that conclusion to be wrong. The idea that important decisions will be more informed and deliberate if they follow some period of reflection does not strike us as unreasonable, particularly where the statute directs that important information become part of the background of the decision. The statute, as construed by the Court of Appeals, permits avoidance of the waiting period in the event of a medical emergency, and the record evidence shows that in the vast majority of cases, a 24-hour delay does not create any appreciable health risk. In theory, at least, the waiting period is a reasonable measure to implement the state's interest in protecting the life of the unborn, a measure that does not amount to an undue burden. Whether the mandatory 24-hour waiting period is nonetheless invalid because in practice it is a substantial obstacle to a woman's choice to terminate her pregnancy is a closer question. The findings of fact by the district court indicate that because of the distances many women must travel to reach an abortion provider, the practical effect will often be a delay of much more than a day because the waiting period requires that a woman seeking an abortion make at least 2 visits to the doctor. The district court also found that in many instances this will increase the exposure of women seeking abortions to the harassment and hostility of anti-abortion protesters demonstrating outside a clinic. As a result, the district court found that for those women who have the fewest financial resources, those who must travel long distances, and those who have difficulty explaining their whereabouts to husbands, employers, or others, the 24-hour waiting period will be particularly burdensome. These findings are troubling in some respects, but they do not demonstrate that the waiting period constitutes an undue burden. We do not doubt that, as the district court held, the waiting period has the effect of increasing the cost and risk of delay of abortions. But the district court did not conclude that the increased costs and potential delays amount to substantial obstacles. Rather, applying the trimester framework's strict prohibition of all regulation designed to promote the state's interest in potential life before viability, the district court concluded that the waiting period does not further the state interest in maternal health and infringes the physician's discretion to exercise sound medical judgment. Yet, as we have stated, under the undue burden standard, a state is permitted to enact persuasive measures which favor childbirth over abortion, even if those measures do not further a health interest. And while the waiting period does limit a physician's discretion, that is not, standing alone, a reason to invalidate it. In light of the construction given the statute's definition of medical emergency by the Court of Appeals and the district court's findings, we cannot say that the waiting period imposes a real health risk. We also disagree with the district court's conclusion that the particularly burdensome effects of the waiting period on some women require its invalidation. A particular burden is not of necessity a substantial obstacle. Whether a burden falls on a particular group is a distinct inquiry from whether it is a substantial obstacle, even as to the women in that group. And the district court did not conclude that the waiting period is such an obstacle, even for the women who are most burdened by it. Hence, on the record before us, and in the context of this facial challenge, we are not convinced that the 24-hour waiting period constitutes an undue burden. We are left with the argument that the various aspects of the informed consent requirement are unconstitutional because they place barriers in the way of abortion on demand. Even the broadest reading of Roe, however, has not suggested that there is a constitutional right to abortion on demand. Rather, the right protected by Roe is a right to decide to terminate a pregnancy free from undue interference by the state. Because the informed consent requirement facilitates the wise exercise of that right, it cannot be classified as an interference with the right Roe protects. The informed consent requirement is not an undue burden on that right. Section 3209 of Pennsylvania's abortion law provides, except in cases of medical emergency, that no physician shall perform an abortion on a married woman without receiving a signed statement from the woman that she has notified her spouse that she is about to undergo an abortion. The woman has the option of providing an alternative signed statement certifying that her husband is not the man who impregnated her, that her husband could not be located, that the pregnancy is the result of spousal sexual assault, which she has reported, or that the woman believes that notifying her husband will cause him or someone else to inflict bodily injury upon her. A physician who performs an abortion on a married woman without receiving the appropriate signed statement will have his or her license revoked and is liable to the husband for damages. The district court heard the testimony of numerous expert witnesses and made detailed findings of fact regarding the effect of this statute. These included: the vast majority of women consult their husbands prior to deciding to terminate their pregnancy. The bodily injury exception could not be invoked by a married woman whose husband, if notified, would, in her reasonable belief, threaten to A. publicize her intent to have an abortion to family, friends, or acquaintances, B. retaliate against her in future child custody or divorce proceedings, C. inflict psychological intimidation or emotional harm upon her children, or other persons, D. inflict bodily harm on other persons such as children, family members, or other loved ones, or E. use his control over finances to deprive of necessary monies for herself or her children. Studies reveal that family violence occurs in 2 million families in the United States. This figure, however, is a conservative one that substantially understates, because battering is usually not reported until it reaches life-threatening proportions, the actual number of families affected by domestic violence. In fact, researchers estimate that 1 of every 2 women will be battered at some time in their life. A wife may not elect to notify her husband of her intention to have an abortion for a variety of reasons, including the husband's illness, concern about her own health, the imminent failure of the marriage, or the husband's absolute opposition to the abortion. The required filing of the spousal consent form would require plaintiff clinics to change their counseling procedures and force women to reveal their most intimate decision making on pain of criminal sanctions. The confidentiality of these revelations could not be guaranteed since the woman's records are not immune from subpoena. Women of all class levels, educational backgrounds, and racial, ethnic, and religious groups are battered. Wife battering or abuse can take on many physical and psychological forms. The nature and scope of the battering can cover a broad range of actions and be gruesome and tortuous. Married women victims of battering have been killed. Married women victims of battering have been killed in Pennsylvania and throughout the United States. Battering can often involve a substantial amount of sexual abuse, including marital rape and sexual mutilation. In a domestic abuse situation, it is common for the battering husband to also abuse the children in an attempt to coerce the wife. Mere notification of pregnancy is frequently a flashpoint for battering and violence within the family. The number of battering incidents is high during the pregnancy, and often the worst abuse can be associated with pregnancy. The battering husband may deny parentage and use the pregnancy as an excuse for abuse. Secrecy typically shrouds abusive families. Family members are instructed not to tell anyone, especially police or doctors, about the abuse and violence. Battering husbands often threaten their wives or her children with further abuse if she tells an outsider of the violence and tells her that nobody will believe her. A battered woman, therefore, is highly unlikely to disclose the violence against her for fear of retaliation by the abuser. Even when confronted directly by medical personnel or other helping professionals, battered women often will not admit to the battering because they have not admitted to themselves that they are battered. A woman in a shelter or a safe house, unknown to her husband, is not reasonably likely to have bodily harm inflicted upon her by her batterer. However, her attempt to notify her husband pursuant to subsection 3209 could accidentally disclose her whereabouts to her husband. Her fear of future ramifications would be realistic under the circumstances. Marital rape is rarely discussed with others or reported to law enforcement authorities, and of those reported, only few are prosecuted. It is common for battered women to have sexual intercourse with their husbands to avoid being battered. While this type of coercive sexual activity would be spousal sexual assault as defined by the Act, many women may not consider it to be so, and others would fear disbelief. The marital rape exception to Section 3209 cannot be claimed by women who are victims of coercive sexual behavior other than penetration. The 90-day reporting requirement of the spousal sexual assault statement, or the spousal sexual assault statute, further narrows the class of sexually abused wives who can claim the exception, since many of these women may be psychologically unable to discuss or report the rape for several years after the incident. Because of the nature of the battering relationship, battered women are unlikely to avail themselves of the exceptions to Section 3209 of the Act, regardless of whether the section applies to them. These findings are supported by studies of domestic violence. The American Medical Association, the AMA, has published a summary of the recent research in this field, which indicates that in an average 12-month period in this country, approximately 2 million women are the victims of severe assaults by their male partners. In a 1985 survey, women reported that nearly one of every eight husbands had assaulted their wives during the past year. The AMA views these figures as marked underestimates. Because the nature of these incidents discourages women from reporting them, and because surveys typically exclude the very poor, those who do not speak English well, and women who are homeless or in institutions or hospitals when the survey is conducted. According to the AMA, researchers on family violence agree that the true incidence of partner violence is probably double the above estimates, or 4 million severely assaulted women per year. Studies on prevalence suggest that from 1/5 to 1/3 of all women will be physically assaulted by a partner or ex-partner during their lifetime. Thus, on an average day in the United States, nearly 11,000 women are severely assaulted by their male partners. Many of these incidents involve sexual assault. In families where wife beating takes place, moreover, child abuse is often present as well. Other studies filled in the rest of this troubling picture. Physical violence is only the most visible form of abuse. Psychological abuse, particularly forced social and economic isolation of women, is also common. Many victims of domestic violence remain with their abusers, perhaps because they perceive no superior alternative. Many abused women who find temporary refuge in shelters return to their husbands, in large part because they have no other source of income. Returning to one's abuser can be dangerous. Recent Federal Bureau of Investigation statistics disclose that 8.8% of all homicide victims in the United States are killed by their spouses. 30% of female homicide victims are killed by their male partners. The limited research that has been conducted with respect to notifying one's husband about an abortion, although involving samples too small to be representative, also supports the district court's findings of fact. The vast majority of women notify their male partners of their decision to obtain an abortion. In many cases in which married women do not notify their husbands, the pregnancy is the result of an extramarital affair. Where the husband is the father, the primary reason women do not notify their husbands is that the husband and wife are experiencing marital difficulties, often accompanied by incidents of violence. This information and the district court's findings reinforce what common sense would suggest. In well-functioning marriages, spouses discuss important intimate decisions such as whether to bear a child, but there are millions of women in this country who are the victims of regular physical and psychological abuse at the hands of their husbands. Should these women become pregnant, they may have very good reasons for not wishing to inform their husbands of their decision to obtain an abortion. Many may have justifiable fears of physical abuse and may be no less fearful of the consequences of reporting prior abuse to the Commonwealth of Pennsylvania. Many may have a reasonable fear that notifying their husbands will provoke further instances of child abuse. These women are not exempt from subsection 3209's notification requirement. Many may fear devastating forms of psychological abuse from their husbands, including verbal harassment, threats of future violence, the destruction of possessions, physical confinement to the home, the withdrawal of financial support, or the disclosure of the abortion to family and friends. These methods of psychological abuse may act as even more of a deterrent to notification than the possibility of physical violence, but women who are the victims of the abuse are not exempt from 3209's notification requirement. And many women who are pregnant as a result of sexual assaults by their husbands will be unable to avail themselves of the exception for spousal sexual assault. Because the exception requires that the woman have notified law enforcement authorities within 90 days of the assault, and her husband will be notified of her report once the investigation begins. If anything in this field is certain, it is that victims of spousal sexual assault are extremely reluctant to report the abuse to the government. Hence, a great many spousal rape victims will be exempt from the notification requirement imposed by subsection 3209. The spousal notification requirement is thus likely to prevent a significant number of women from obtaining an abortion. It does not merely make abortions a little more difficult or expensive to obtain for many women, it will impose a substantial obstacle. We must not blind ourselves to the fact that the significant number of women who fear for their safety and the safety of their children are likely to be deterred from procuring an abortion as surely as if the Commonwealth had outlawed abortion in all cases. Respondents attempt to avoid the conclusion that subsection 3209 is invalid by pointing out that it imposes almost no burden at all for the vast majority of women seeking abortions. They begin by noting that about 20% of the women who obtain abortions are married. They note that of these women, about 95% notify their husbands of their own volition. Thus, respondents argue the effects of 3209 are felt by only 1% of the women who obtain abortions. Respondents argue that since some of these women will be able to notify their husbands without adverse consequences or will qualify for one of the exceptions, the statute affects fewer than 1% of women seeking abortions. For this reason, it is asserted, the statute cannot be invalid on its face. We disagree with respondents' basic method of analysis. The analysis does not end with the 1% of women upon whom the statute operates. It begins there. Legislation is measured for consistency with the Constitution by its impact on those whose conduct it affects. For example, we would not say that a law which requires a newspaper to print a candidate's reply to an unfavorable editorial is valid on its face because most newspapers would adopt the policy even absent the law. The proper focus of constitutional inquiry is the group for whom the law is a restriction, not the group for whom the law is irrelevant. Respondent's argument itself gives implicit recognition to this principle at one of its critical points. Respondents speak of the 1% of women seeking abortions who are married and would choose not to notify their husbands of their plans. By selecting as the controlling class women who wish to obtain abortions rather than all women or all pregnant women, respondents in effect concede that subsection 3209 must be judged by reference to those for whom it is an actual rather than irrelevant restriction. Of course, as we have said, subsection 3209's real target is narrower even than the class of women seeking abortions identified by the state. It is married women seeking abortions who do not wish to notify their husbands of their intentions and who do not qualify for one of the statutory exceptions to the notice requirement. The unfortunate yet persistent conditions we document above will mean that in a large fraction of the cases in which subsection 3209 is relevant, it will operate as a substantial obstacle to a woman's choice to undergo an abortion. It is an undue burden and therefore invalid. This conclusion is in no way inconsistent with our decisions upholding parental notification or consent requirements. Those enactments and our judgment that they are constitutional are based on the quite reasonable assumption that minors will benefit from consultation with their parents, and that children will often not realize that their parents have their best interests at heart. We cannot adopt a parallel assumption about adult women. We recognize that a husband has a deep and proper concern and interest in his wife's pregnancy and in the growth and development of the fetus she is carrying. With regard to the children he has fathered and raised, the court has recognized his cognizable and substantial interest in their custody. If these cases concerned a state's ability to require the mother to notify the father before taking some action with respect to a living child raised by both, therefore, it would be reasonable to conclude, as a general matter, that the father's interest in the welfare of the child and the mother's interest are equal. Before birth, however, the issue takes on a very different cast. It is an inescapable biological fact that state regulation with respect to the woman It is an inescapable biological fact that state regulation with respect to the child a woman is carrying will have a far greater impact on the mother's liberty than on the father's. The effect of state regulation on a woman's protected liberty is doubly deserving of scrutiny in such a case, as the state has touched not only upon the private sphere of the family, but upon the very bodily integrity of the pregnant woman. The court has held that when the wife and the husband disagree on the decision, the view of only one of the two marriage partners can prevail. Inasmuch it is the woman who physically bears the child and who is the more directly and immediately affected by the pregnancy, as between the two, the balance weighs in her favor. This conclusion rests upon the basic nature of marriage and the nature of our Constitution. The marital couple is not an independent entity with a mind and heart of its own, but an association of two individuals, each with a separate intellectual and emotional makeup. If the right of privacy means anything, it is the right of the individual, married or single, to be free from unwarranted governmental intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child. Quoting Eisenstadt v. Baird. The Constitution protects individuals, men and women alike, from unjustified state interference, even when that interference is enacted into law for the benefit of their spouses. There was a time not so long ago when a different understanding of the family and of the Constitution prevailed. In Bradwell v. State, 3 members of this court reaffirmed the common law principle that a woman had no legal existence separate from her husband, who was regarded as her head and representative in the social state. And notwithstanding some recent modifications of this civil status, many of the special rules of law flowing from and dependent upon this cardinal principle still exist in full force in most states. Only one generation has passed since this court observed that woman is still regarded as the center of home and family life, with attendant special responsibilities that precluded full and independent legal status under the Constitution. Quoting Hoyt v. Florida. These views, of course, are no longer consistent with our understanding of the family, the individual, or the Constitution. In keeping with our rejection of the common law understanding of a woman's role within the family, the court held in Danforth that the Constitution does not permit a state to require a married woman to obtain her husband's consent before undergoing an abortion. The principles that guided the court in Danforth should be our guides today. For the great many women who are victims of abuse inflicted by their husbands or whose children are the victims of such abuse, a spousal notice requirement enables the husband to wield an effective veto over his wife's decision. Whether the prospect of notification itself deters such women from seeking abortions, or whether the husband, through physical force or psychological pressure or economic coercion, prevents his wife from obtaining an abortion until it is too late. The notice requirement will often be tantamount to the veto found unconstitutional in Danforth. The women most affected by this law, those who most reasonably fear the consequences of notifying their husbands that they are pregnant, are in the gravest danger. The husband's interest in the life of the child his wife is carrying does not permit the state to empower him with this troubling degree of authority over his wife. The contrary view leads to consequences reminiscent of the common law. A husband has no enforceable right to require a wife to advise him before she exercises her personal choices. If a husband's interest in the potential life of the child outweighs a wife's liberty, the state could require a married woman to notify her husband before she uses a post-fertilization contraceptive. Perhaps next in line would be a statute requiring pregnant married women to notify their husbands before engaging in conduct causing risks to the fetus. After all, if the husband's interest in the fetus's safety is a sufficient predicate for state regulation, the state could reasonably conclude that pregnant wives should notify their husbands before drinking alcohol or smoking. Perhaps married women should notify their husbands before using contraceptives or before undergoing any type of surgery that may have complications affecting the husband's interest in his wife's reproductive organs. And if a husband's interest justifies notice in any of these cases, one might reasonably argue that it justifies exactly what the Danforth court held. It did not justify a requirement of the husband's consent as well. A state may not give to a man the kind of dominion over his wife that parents exercise over their children. Section 3209 embodies a view of marriage consonant with the common law status of married women, but repugnant to our present understanding of marriage and of the nature of the rights secured by the Constitution. Women do not lose their constitutionally protected liberty when they marry. The Constitution protects all individuals, male or female, married or unmarried, from the abuse of governmental power, even where the power is employed for the supposed benefit of a member of the individual's family. These considerations confirm our conclusion that subsection 3209 is invalid. We next consider the parental consent provision. Except in a medical emergency, an unemancipated young woman under 18 may not obtain an abortion unless she and one of her parents or guardian provides informed consent as defined above. If neither a parent nor a guardian provides consent, a court may authorize the performance of an abortion upon a determination that the young woman is mature and capable of giving informed consent and has in fact given her informed consent, or that an abortion would be in her best interests. We have been over most of this ground before. Our case is established, and we reaffirm today that a state may require a minor seeking an abortion to obtain the consent of a parent or guardian, provided that there is an adequate judicial bypass procedure. Under these precedents, in our view, the one-parent consent requirement and judicial bypass procedure are constitutional. The only argument made by petitioners respecting this provision, and to which our prior decisions do not speak, is the contention that the parental consent requirement is invalid because it requires informed parental consent. For the most part, petitioners' argument is a reprise of their argument with respect to the informed consent requirement in general, and we reject it for the reasons given above. Indeed, some of the provisions regarding informed consent have particular force with respect to minors. The waiting period, for example, may provide the parents or parents of the pregnant young woman the opportunity to consult with her in private and to discuss the consequences of her decision in the context of the values and moral or religious principles of their family. Under the record-keeping and reporting requirements of the statute, every facility which performs abortions is required to file a report stating its name and address, as well as the name and address of any related entity, such as a controlling or subsidiary organization. In the case of state-funded institutions, the information becomes public. For each abortion performed, a report must be filed identifying the physician and the second physician where required, the facility, the referring physician or agency, the woman's age, the number of prior pregnancies and prior abortions she has had, gestational age, the type of abortion procedure, the date of the abortion, whether there were any pre-existing medical conditions which would complicate pregnancy, medical complications with the abortion, where applicable, the basis for the determination that the abortion was medically necessary, the weight of the aborted fetus, and whether the woman was married, and if so, whether notice was provided on the basis for the failure to give notice. Let me reread that. Whether notice was provided or the basis for the failure to give notice. Every abortion facility must also file quarterly reports showing the number of abortions performed broken down by trimester. In all events, the identity of each woman who has had an abortion remains confidential. In Danforth, we held that record-keeping and reporting provisions that are reasonably directed to the preservation of maternal health and that properly respect a patient's confidentiality and privacy are permissible. We think that under this standard, all the provisions at issue here, except that relating to spousal notice, are constitutional. Although they do not relate to the state's interest in informing the woman's choice, they do relate to health. The collection of information with respect to actual patients is a vital element of medical research, and so it cannot be said that the requirements serve no purpose other than to make abortions more difficult. Nor do we find that the requirements impose a substantial obstacle to a woman's choice. At most, they might increase the cost of some abortions by a slight amount. While at some point increased costs could become a substantial obstacle, there is no such showing on the record before us. Subsection 12 of the reporting provision requires the reporting of, among other things, a married woman's reason for failure to provide notice to her husband. This provision, in effect, requires women, as a condition of obtaining an abortion, to provide the Commonwealth with the precise information we have already recognized that many women have pressing reasons not to reveal. Like the spousal notice requirement itself, this provision places an undue burden on a woman's choice and must be invalidated for that reason. Our Constitution is a covenant running from the first generation of Americans to us and then to future generations. It is a coherent succession. Each generation must learn anew that the Constitution's written terms embody ideas and aspirations that must survive more ages than one. We accept our responsibility not to retreat from interpreting the full meaning of the covenant in light of all our precedents. We invoke it once again to define the freedom guaranteed by the Constitution's own promise, the promise of liberty. The judgment in number 91-902 is affirmed. The judgment in number 91-744 is affirmed in part and reversed in part, and the case is remanded for proceedings consistent with this opinion, including consideration of the question of severability. It is so ordered. Okay, so this is the appendix. Oh, this is the actual law. I'm just going to skip over that. Okay, so this is the appendix, and it ends right about here. Okay. Justice Stevens, concurring in part and dissenting in part. The portions of the court's opinion that I have joined are more important than those with which I disagree. I shall therefore first comment on significant areas of agreement, and then explain the limited character of my disagreement. The court is unquestionably correct, including that the doctrine of stare decisis has controlling significance in a case of this kind, notwithstanding an individual justice's concerns about the merits. The central holding of Roe v. Wade has been part of our law for almost 2 decades. It was a natural sequel to the protection of individual liberty established in Griswold. The societal costs of overruling Roe at this late date would be enormous. Roe is an integral part of a correct understanding of both the concept of liberty and the basic equality of men and women. Stare decisis also provides a sufficient basis for my agreement with the joint opinion's reaffirmation of Roe's post-viability analysis. Specifically, I accept the proposition that if the state is interested in protecting fetal life after viability, it may go so far as to proscribe abortion during that period, except when it is necessary to preserve the life or health of the mother. I also accept what is implicit in the court's analysis, namely a reaffirmation of Roe's explanation of why the state's obligation to protect the life or health of the mother must take precedence over any duty to the unborn. The court in Roe carefully considered and rejected the state's argument that the fetus is a person within the language and meaning of the 14th Amendment. After analyzing the usage of person in the Constitution, the court concluded that the word has application only postnatally. Commenting on the contingent property interests of the unborn that are generally represented by guardians ad litem, the court noted, perfection of the interests involved, again, has generally been contingent upon live birth. In short, the unborn have never been recognized in the law as persons in the whole sense. Accordingly, an abortion is not the termination of life entitled to 14th Amendment protection. From this holding, there was no dissent. Indeed, no member of the court has ever questioned this fundamental proposition. Thus, as a matter of federal constitutional law, a developing organism that is not yet a person does not have what is sometimes described as a right to life. This has been, and by the court's holding today, remains a fundamental premise of our constitutional law governing reproductive autonomy. My disagreement with joint opinion begins with its understanding of the trimester framework established in Roe. Contrary to suggestion of the joint opinion, it is not a contradiction to recognize that the state may have a legitimate interest in potential human life and at the same time to conclude that that interest does not justify the regulation of abortion before viability, although other interests, such as maternal health, may. The fact that the state's interest is legitimate does not tell us when, if ever, that interest outweighs the pregnant woman's interest in personal liberty. It is appropriate, therefore, to consider more carefully the nature of the interests at stake. First, it is clear that, in order to be legitimate, the state's interest must be secular, consistent with the First Amendment. The state may not promote a theological or sectarian interest. Moreover, as discussed above, the state interest in potential human life is not an interest in loco parentis, for the fetus is not a person. Identifying the state's interests, which the states rarely articulate with any precision, makes clear that the interest in protecting potential life is not grounded in the Constitution. It is, instead, an indirect interest supported by both humanitarian and pragmatic concerns. Many of our citizens believe that any abortion reflects an unacceptable disrespect for potential human life and that the performance of more than 1 million abortions each year is intolerable. Many find third trimester abortions performed when the fetus is approaching personhood particularly offensive. The state has a legitimate interest in minimizing such offense. The state may also have a broader interest in expanding the population, believing society would benefit from the services of additional productive citizens, or that the potential human lives might include the occasional Mozart or Marie Curie. These are the kinds of concerns that comprise the state's interest in potential human life. In counterpoise, this is the woman's constitutional interest in liberty. One aspect of this liberty is a right to bodily integrity, a right to control one's person. This right is neutral on the question of abortion. The Constitution would be equally offended by an absolute requirement that all women undergo abortions as by an absolute prohibition on abortions. Our whole constitutional heritage rebels at the thought of giving government the power to control men's minds. The same holds true for the power to control women's bodies. The woman's constitutional liberty interest also involves her freedom to decide matters of the highest privacy and the most personal nature. A woman considering abortion faces a difficult choice, having serious and personal consequences of major importance to her own future, perhaps to the salvation of her own immortal soul. The authority to make such traumatic and yet empowering decisions is an element of basic human dignity. As the joint opinion so eloquently demonstrates, a woman's decision to terminate her pregnancy is nothing less than a matter of conscience. Weighing the state's interest in potential life and the woman's liberty interest, I agree with the joint opinion that the state may express a preference for normal childbirth, that the state may take steps to ensure that a woman's choice is thoughtful and informed, and that states are free to enact laws to provide a reasonable framework for a woman to make a decision that has such profound and lasting meaning. Serious questions arise, however, when a state attempts to persuade the woman to choose childbirth over abortion. Decisional autonomy must limit the state's power to inject into a woman's most personal deliberations its own views of what is best. The state may promote its preferences by funding childbirth, by creating and maintaining alternatives to abortion, and by espousing the virtues of family, but it must respect the individual's freedom to make such judgments. This theme runs throughout our decisions concerning reproductive freedom. In general, Roe's requirement that restrictions on abortions before viability be justified by the state's interest in maternal health has prevented states from interjecting regulations designed to influence a woman's decision. Thus, we have upheld regulations of abortion that are not efforts to sway or direct a woman's choice, but rather are efforts to enhance the deliberative quality of that decision, or are neutral regulations on the health aspects of her decision. We have, for example, upheld regulations requiring written informed consent, limiting limited record keeping and reporting, and pathology reports, as well as various licensing and qualification provisions. Conversely, we have consistently rejected state efforts to prejudice a woman's choice, either by limiting the information available to her or by requiring the delivery of information designed to influence the woman's informed choice between abortion or childbirth. In my opinion, the principles established in this long line of cases and the wisdom reflected in Justice Powell's opinion for the court in Akron and followed by the court just 6 years ago in Thornburg should govern our decisions today. Under these principles, Pennsylvania Constitution has subsections 3205A to I 1 to 3 of the Pennsylvania statute are unconstitutional. Those sections require a physician or a counselor to provide the woman with a range of materials clearly designed to persuade her to choose not to undergo the abortion. While the Commonwealth is free, pursuant to subsection 3208 of the Pennsylvania law, to produce and disseminate such material, the Commonwealth may not inject such information into the woman's deliberations just as she is weighing such an important choice. Under this analysis, subsections 3205A11 and 3 of the Pennsylvania statute are constitutional. Those sections which require the physician to inform a woman of the nature and risks of the abortion procedure and the medical risks of carrying to term are neutral requirements comparable to those imposed in other medical procedures. Those sections indicate no effort by the Commonwealth to influence the woman's choice in any way. If anything, such requirements enhance rather than skew the woman's decision-making. The 24-hour waiting period required by subsections 3205A1 and 2 of the Pennsylvania statute raises even more serious concerns. Such a requirement arguably furthers the Commonwealth's interests in two ways, neither of which is constitutionally permissible. First, it may be argued that the 24-hour delay is justified by the mere fact that it is likely to reduce the number of abortions, thus furthering the Commonwealth's interest in potential life. But such an argument would justify any form of coercion that placed an obstacle in the woman's path. The Commonwealth cannot further its interests by simply wearing down the ability of the pregnant woman to exercise her constitutional right. Second, it can more reasonably be argued that the 24-hour delay furthers the Commonwealth's interest in ensuring that the woman's decision is informed and thoughtful, but there is no evidence that the mandated delay benefits women or that it is necessary to enable the physician to convey any relevant information to the patient. The mandatory delay thus appears to rest on outmoded and unacceptable assumptions about the decision-making capacity of women. While there are well-established and consistently maintained reasons for the Commonwealth to view with skepticism the ability of minors to make decisions, none of those reasons applies to an adult woman's decision-making ability. Just as we have left behind the belief that a woman must consult her husband before undertaking serious matters, so we must reject the notion that a woman is less capable of deciding matters of gravity. In the alternative, the delay requirement may be premised on the belief that the decision to terminate a pregnancy is presumptively wrong. This premise is illegitimate. Those who disagree vehemently about the legality and morality of abortion agree about one thing. The decision to terminate a pregnancy is profound and difficult. No person undertakes such a decision lightly, and states may not presume that No person undertakes such a decision lightly, and states may not presume that a woman has failed to reflect adequately merely because her conclusion differs from the state's preference. A woman who has, in the privacy of her thoughts and conscience, weighed the options and made her decisions cannot be forced to reconsider all simply because the state believes she has come to the wrong conclusion. Part of the constitutional liberty to choose is the equal dignity to which each of us is entitled. A woman who decides to terminate her pregnancy is entitled to the same respect as a woman who decides to carry the fetus to term. The mandatory waiting period denies women that equal respect. In my opinion, a correct application of the undue burden standard leads to the same conclusion concerning the constitutionality of these requirements. A state-imposed burden on the exercise of a constitutional right is measured both by its effects and by its character. A burden may be undue either because the burden is too severe or because it lacks a legitimate rational justification. The 24-hour delay requirement fails both parts of this test. The findings of the district court establish the severity of the burden, that the 24-hour delay imposes on many pregnant women. Yet even in those cases in which the delay is not especially onerous, it is, in my opinion, undue because there is no evidence that such a delay serves a useful and legitimate purpose. As indicated above, there is no legitimate reason to require a woman who has agonized over her decision to leave the clinic or hospital and return again another day. While a general requirement that a physician notify her patients about the risks of a proposed medical procedure is appropriate, a rigid requirement that all patients wait 24 hours or, what is true in practice, much longer to evaluate the significance of information that is either common knowledge or irrelevant is an irrational and therefore undue burden. The counseling provisions are similarly infirm. Whenever government commands private citizens to speak or to listen, careful review of the justification for that command is particularly appropriate. In these cases, the Pennsylvania statute directs that counselors provide women seeking abortions with information concerning alternatives to abortion, the availability of medical assistance benefits, and the possibility of child support payments. The statute requires that this information be given to all women seeking abortions, including those for whom such information is clearly useless, such as those who are married, those who have undergone the procedure in the past, or are fully aware of the options, and those who are fully convinced that abortion is the only reasonable option. Moreover, the statute requires physicians to inform all of their patients of the probable gestational age of the unborn child. This information is of little decisional value in most cases, because 90% of all abortions are performed during the first trimester, when fetal age has less relevance than when the fetus nears viability. Nor can the information required by the statute be justified as relevant to any philosophic or social argument, either favoring or disfavoring the abortion decision in a particular case. In light of all of these facts, I conclude that the information requirement in subsection 3205A1-2 and subsections 3205A2-1 through 3 do not serve a useful purpose and thus constitute an unnecessary and therefore undue burden on the woman's constitutional liberty to decide to terminate her pregnancy. Accordingly, while I disagree with parts 4, 5b, and 5d of the joint opinion, I join the remainder of the court's opinion. Okay, I will stop there for now, and I'll come back with part 2. But as always, if there's anything you'd like me to read, just drop in the comments, and I'm happy to take a look. Thank you.